with all these different housing products, I think the first thing to find out is what's the highest and best use of my property. Forget about how I'm going to divide it. Forget about how I'm going to condo it or unit subdivide it or lot split it. What can I build on this property? The parent parcel has a certain yield in terms of number of dwellings, square footage, those kinds of things, and figure out what the maximum amount of build out could possibly be, and then pick one of those tools that's a good and suitable fit for the way in which you want to separate the ownership, whether that be municipally subdividing through a short plat or unit subdivision, whether that's a lot split that's municipally reviewed that only gives you one, or whether that's the condo that we've already been doing for the last 5 years to just separate ownership in however you want based on what you're building.
Hello, Terry. Thanks for coming on with us today. It's been quite some time since we did the earlier video, and Terry phase one in his different appearance, and you're looking much different, but just as your appearance has changed, many of the codes have changed in Washington too. So looking forward to having this conversation today.
Thanks for having me, Jess. Great to see you. Yeah, our last video we did a few years ago, I sometimes get calls and say, I saw your other attorney on the YouTube video, and I don't even bother to correct him. I just tell him that guy's pretty smart. He kind of knew his stuff back then as well.
Hey, Terry. I look forward to chatting with you guys. And, this version of you is, I guess, the only version I know, but it's a pretty good version. So
appreciate it. Yeah. And I mean, the beard, it's kind of funny. I brought this little sculpture here. I'm kind of trying to look like this prospector guy from the late 1800s. We're in the wild west trying to find gold in the backyard, and the sort of wild west pioneering outdoors ethic. I think it fits the paradigm, at least mentally, for this sort of new pioneering direction that things are going with real estate. It's kind of the uncharted territory in a lot of ways.
Well, good. Well, let's jump in. So we've had some changes here. For example, what is this new lot splitting bill, House Bill 1096, and other changes we have coming up? And what is it? Why is it such a big deal for homeowners and developers in Washington?
Yeah, a lot of neat new opportunities are coming forward now. Some know already that for the last 5 years we've been seeing a lot of proliferation of what we are also calling middle housing. It's not technically definition middle housing, but it's the accessory dwelling unit model in Seattle and Kirkland. And over the last 5 years, both of those jurisdictions have done a large volume of these building permits. And then we use a variety of tools to divide those for ownership, which has primarily been the use of the condominium in a more subdivision manner. But the new lot splitting bill that you're talking about is interesting. And there's also some new implementations for what's called unit subdivisions that are coming online even sooner than the lot splitting is. And it may be helpful, I think, to zoom out. There's so much terminology here that's difficult sometimes to follow. All of these things are common interest communities. There's more than one owner in this community, whether it's a condominium, whether it's a subdivision that's municipally reviewed like a short plat or a plat. Some folks will refer to unit subdivisions where the subdivision's municipally reviewed, sitting on top of building plans. And then the lot split, which is kind of a little unit subdivision light, I guess you would say. It's subdividing off one little piece without having to go through as much of the jurisdictional processes that some of the other processes do. But all these things are known as common interest communities. And really this stuff goes back to 2018 with the implementation of RCW 6490 that we call the Wakaiwa Act. It's the Washington Uniform Common Interest Ownership Act. And that really began the process in earnest the last 6 years of saying, hey, all of these things are just forms of ownership. Whether you go through a municipal subdivision, which is 9 lots or less, or 10 lots or more if it's a short plat or a plat, and then unit subdivisions if it's tied to the building permit, or now the lot split. Those are all municipal examples of ways to separate off ownership. Condominiums being used very similarly to draw lines on the ground rather than the traditional condominium where you draw the lines within the walls in, as they say, within a high-rise traditional condominium. So most of the new condominiums you see are these more subdivision-looking kinds of maps. And all of those things are part of the same Wakaiwa, same Chapter 6490. And municipally, it's whatever you can get a building permit for. There's going to be some way for you to divide these up into separate ownership, whether you go through the municipal process or the condominium process.
So for someone that owns a single family residential lot or in a residential zone, what steps would they take to start these processes?
Yeah, well, and you've done some classes on the ZATSUM an acronym that goes into a lot of the details about sort of the feasibility aspects of it. When you look at title and you look at utilities and topography and soil and all the different things, our part in the legal side, kind of comes more along the lines of if you've done that feasibility and figured out what you can municipally build, then we look at the way you subdivide or the way that you create condominiums for separate ownership so that the community, once it's created and it has these separate owners, can function well together, whether we're talking about sharing walkways or driveways or parking areas or trash areas. I mean, you think about these different sites, right? They might have had one home on them for 100 years and they had 3 garbage cans, a garbage, a yard waste, and a recycle. And those 3 containers, now you have 4 units on a lot, and now you have 3 cans for each person. So suddenly you've got 12 different cans. Where are those going to go? It's just one little thing like that, but it's not really being thought of as much during the building permit process, because the building permit's just looking at what are you going to build. It's not looking at how you're going to own it. And really where most of our clients find, I guess, the special sauce in all of this new stuff is how do we own this separately? Because once I can own something separately, I can sell one thing, keep another. I can refinance and put all my loan on one, but free and clear the other. Maybe open up opportunity for lines of credit or other types of financing leverages against properties I've now created, because they all get their own separate tax parcel numbers. They include their own yard. They really all treated separately. And so that's the way things have moved now. You have all these different options. The last 5 years, it's just been really the accessory dwelling unit options. That's what Seattle and Kirkland did in their pioneering stages, and they allow 3 dwelling units on a single family lot. So we already have sort of a wholesale change away from the idea that they're single family. It's really multifamily. It's really 3 dwelling units on even a 3,500 square foot little postage stamp size lot in Seattle can have 3 dwelling units on it if it can get its buildings in there. And so that now you're going to see in the next couple months this new product line, which is House Bill 1110, being implemented with cottage housing, duplex, triplex, quadplex, even sixplex if you're within a shorter distance to transit. And that's a different product than the accessory dwelling unit. That product takes a look at, first of all, how many units are you going to put on the lot? If you're going to do 4, which you're allowed to do now, then that gives you a density of 1 dwelling unit per however many square feet based on the overall size of your lot. So for example, if you've got an 8,000 square foot lot and you're going to put 4 homes on there, that's 1 per 2,000. Well, that density of 1 per 2,000 then gets plugged into a matrix to figure out what your floor area ratio is, which is how much square footage you can have. And that's going to open up some opportunities for folks, because under the last 5 years, what we've seen is the primary home has generally been the bigger home on the site. You take the calculation of the square footage of the property, and you get, in Seattle, for example, you take 50% of that, and that gives you the floor area ratio for the square footage of the primary home. So if you have a 5,000 square foot lot, you can build a 2,500 square foot home. 8,000 square foot lot, maybe a 4,000 square foot home. So you have one big house. And then the accessory dwelling units have been capped at 1,000 square feet, or 1,200 in Kirkland. So they're smaller, and you have these communities now with 1 big home, 2 small homes. Well, the new House Bill 1110 implementation with the cottage housing, duplex, triplex, quadplex, and even sixplex, you're going to see a model that maybe more evenly distributes that floor area ratio amongst 4 of the dwellings, or up to 6 of the dwellings in the cases of being closer to transit. Instead of having 1 big house and several smaller homes, you're going to now maybe have 4 that are all around the same size based on what you're allowed to do. That's going to give you a little bit of a bump in terms of not just having to be restricted to 1,000, but it's also going to mean that the product's going to look more similar rather than 1 big house and smaller houses. And to be honest with you, over the last 5 years, a lot of developers have already gone to that model in the accessory dwelling unit paradigm, because they've found that the market is more open to houses that are quote unquote a little more affordable, meaning instead of a couple $1,000,000 for a home, maybe it's closer to 800,000 or 900,000, and so they make their single family home and their accessory dwelling units all similar in size in order to capture that market that's a little more in that moderate price point.
And so you get there to what the market's demanding, but we did talk about limitations, and you brought up ZATSUM, which I work with clients on, because there's going to be some limitations like minimum lot size, utility requirements, zoning constraints, environmental constraints. So there's all those things someone's going to have to look through and try to work through to figure out what it is and how I might go forward with this. So yeah, and one thing we just started talking about the lot splitting, but these other things you're talking about with the unit lot subdivision. So how do these all interact with one another under middle housing? I mean, can you build all duplexes and ADUs or clusters? I mean, they're all open for people to do.
All of those things are on the table, or at least are coming. You have currently already the last 5 years in Seattle and Kirkland, and now as each new city comes online, you're going to have this sort of model that's become a little bit familiar for the last 5 years of the single family plus two more. And when you do the two more, they're going to be accessory dwelling units that are 1,000 square feet or 1,200 square feet or whatever that jurisdiction says. They can't make it required to be anything less than 1,000. So you're going to have that model, which is already kind of played through. We already know we have thousands of examples. Our firm does one a day, every business day. So over the last several years, there's several thousand units just in our one firm, and we only represent about a third of the market. So it gives you a little bit of idea as to scope and scale that these are going on in large volumes and quantities already. And that model will continue to be available now with all the cities that are coming online. There's 70 to 80 cities now throughout Washington that are impacted by these state mandated bills. And so the other model with the duplex, triplex, quadplex, or sixplex or cottage housing arrangements, that's also coming online in all the jurisdictions, and it's not yet been done because nobody's opened up their program for that yet. But one of the things that will be a little different about that is that with the last 5 years, the accessory dwelling unit, there's been no way to divide those municipally. You haven't been able to, you can build them, but you can't separate them for ownership through a subdivision process at the city level. So the condo has been used to create a very similar feel with a condominium that feels like a subdivision. Whereas these new House Bill 1110 duplex, triplex, quadplex products are going to have the ability to possibly do what's called a unit subdivision. And a unit subdivision is a municipal process that reviews administratively different aspects of the subdivision to create separate lots that are municipally approved. And so for some people, they think, well, that sounds a little bit more familiar than a condo does. And so with a condo, you're going to always have an HOA. With a unit subdivision, you might have an HOA, you might not. And I think in people's minds, particularly if you've been in the industry for a long time, you might have in your mind the thought that a municipal subdivision is maybe a little more attractive. And I'll be honest, in some jurisdictions, as we go to east side places, you think about a Medina or a Bellevue or a place like that, or Redmond, maybe somebody at a higher price point would prefer something that's been municipally divided versus something that's been condominium divided, even though they look exactly the same on the ground. The ownership structure from just a stigmatized manner might seem a little bit more attractive in certain areas. And so that's another tool that'll be available, but you'll have the option. I have Tacoma just came online with their new unit subdivision process, and they may change this and other jurisdictions may follow suit, but right now they have a whole process. And Jeff, you've been through with me over the years subdivisions where you have to go in and have a pre-application meeting first, and you have to present your whole plan, and then when you have that meeting, they give you back feedback about the things they're going to want in your preliminary application. You usually have to go back to some of your vendors, some of your subcontractors, like your surveyor, your engineer, your arborist, your wetland biologist, or whatever, and then respond to those comments from the pre-app meeting in order to submit a preliminary submittal. Then you go through a preliminary submittal. It might be several months in order to get to a preliminary submittal approval with conditions. Those conditions may have infrastructure improvements and other things to do, and you might have engineering and construction and bonding before you can move to a final. And next thing you know, we're in the municipal subdivision process, taking a year or two or even 3 in many cases. And so I think even where the subdivision option is allowed in the unit subdivision municipal fashion with these new House Bill 1110 products, there are going to be some people that just say, I'd like to do a condo because I can get that done in a month or 2. And I don't have to go through any municipal review. I just get a building permit, and then all the subdivision side of it is handled through the condominium mechanism. And if you're not worried about the stigma of the word condo or the word HOA on the project, then I think you'll find that the buyer, in most cases, also doesn't really reckon about one or the other. And so you'll have this option, testing out the various jurisdictions' processes with the unit subdivision versus maybe the privatized condominium route, and kind of weigh which one costs more, which one takes longer, what's the market say, do they care when they're buying, if it's one or the other. And then the lot split, as you mentioned, which is a whole nother layer to add to now what we already know about unit subdivisions and condos is, what about just splitting off one of my properties? And the thing about that is that you're only allowed to do that one time with the property. Once you've done a lot split, you can't further split that lot that you lot split unless you go through another condo or subdivision process, as we talked about as the previous model. So you have all these different tools in the tool belt, and I guess for the lot split, if you're just wanting to build one home in the backyard, and you don't have an intention of doing 3 or 4, and you just want something that's supposed to be a little faster, doesn't require public notice, things like that, then the lot split, once it's implemented in a couple years, may be an option for sort of the backyard options that are back there. But with all these different housing products, I think the first thing to find out is, what's the highest and best use of my property? Forget about how I'm going to divide it. Forget about how I'm going to condo it or unit subdivide it or lot split it. What can I build on this property? The parent parcel has a certain yield in terms of number of dwellings, square footage, those kinds of things, and figure out what the maximum amount of build out could possibly be, and then pick one of those tools that's a good and suitable fit for the way in which you want to separate the ownership, whether that be municipally subdividing through a short plat or unit subdivision, whether that's a lot split that's municipally reviewed that only gives you one, or whether that's the condo that we've already been doing for the last 5 years to just separate ownership and however you want based on what you're building.
Now, Terry, question for you. You mentioned that developers, they try to maximize yield. I think on the other side of that, it's all about minimizing risks. So as we look at, these different product types and these different ways to legally subdivide or add density to a previously single family home lot, I think a question often comes up of, how do condominiums compare in risk to some of these other products, especially concerning warranty and developer liability, concerning the Washington Condo Act?
Those are great questions, and for sure, those are part of, whether it's accurate or not, part of the stigma in terms of the market perceptions about these various products. One of the reasons why somebody might want to municipally divide through a lot split or through a unit subdivision or something similar versus a condo is because in their mind there's been a lot of history, particularly in the high-rise condo field, where there's been some sort of mass construction defect stuff going on, where you've got insurance policies and developers on the hook for many years after the fact. And so what I can tell you is that for the last 5 years, with these thousands of units that have been created in these little accessory dwelling unit models that Seattle and Kirkland have already been doing, we're now 5 years into it, and so I think we would probably see some trends or patterns as to defects if there were really any sort of problems that were creeping in that regard. But this is really not the traditional type of condo, and those ideas that are sort of stigmatized as to defect issues, they're just not the same when you don't have, a 50-unit high-rise that's got a leaky roof or leaky windows, and all the owners are going to be involved in sort of a class action feeling type of litigation, and you've got insurance and attorneys and property managers and everybody kind of that's in that industry that was playing a part of that. Now you have these little 2-unit, 3-unit, 4-unit projects, most of them detached, maybe one of them is attached. And it's just, if there's a problem with a window, if there's a problem with a roof, there's a process you have to go through. You have to give notice to the declarant, the developer, about the issue. They can bring in their own professionals, and you negotiate whether or not it is or isn't a defect. And at the end of the day, there's just not enough money on the table to make it a big fight. And most of the time, it's just something that's going to get fixed. And there is some movement legislatively to propose maybe changing some of these smaller projects that are small condos, 3 units, 4 units, to fit this middle housing, to not even have the more onerous warranty considerations. Because one of the distinctions is there is a 4-year limited warranty of quality in a condominium based on the time of the deed. So it does freeze that moment in time that you sell a unit to having a 4-year window where, if there is one of these defect issues, the developer is supposed to come in and analyze it, and if it's a defect, fix it. Whereas in a non-condo arrangement, a municipal subdivision, like a unit lot subdivision or a lot split when they come, or a short plat or plat, there's whatever you agree to in your contract with the seller and buyer. There can just be a 1-year warranty, which is very commonly done, or maybe it's a 210 warranty to outsource it to an outside firm to handle. And then that may be the limits of all the warranty that's there. There's not this additional 4-year separate warranty that's provided by code based on the time of the deed. And so while you still may be able to contract with a buyer and a seller to curb some of those things, that is something that sort of hangs over the condo. But what we can see is now in 5 years with thousands of units, there's not a massive movement towards condo defect issues in this market. And I work with some of the other law firms in other types of projects that handle those kinds of claims on a regular basis. And the interesting thing is they've had really none in terms of the little 2 and 3 unit projects that have resulted in these big defect cases, because they're just not big cases. And at the end of the day, it's more of an on paper concern than it is in a practical sense what we've actually seen playing out.
Right. And now, amongst your developer clients and your builder clients, are there any trends that you're kind of seeing between the different product types that they're choosing to build? And is it dependent on municipality, or is it, what are those factors that make it decisive whether to go with, a cottage development versus a townhome development versus, a 4 or 6 unit condo development?
Well, to a large degree, we're talking on this interview today at a time where we're at an inflection point. Things are really changing now because of the implementation in both Seattle and Kirkland with the new rules that are coming, as well as all the other cities. It's all brand new. So we haven't really seen anything happening there yet, because for the last 5 years, the only model has really been doing a single family with 2 accessories to get 3 units on a single family lot. The townhome model's been used in the multifamily zones, and typically when folks are doing that, they're going to use a unit subdivision process to lay on top of the building plan in order to subdivide it through the municipal subdivision processes. So not much has really changed in those areas. What's really been a big change is most of the developers that were doing the townhome multifamily zone development have moved all or most of their product into the single family zones, because single family zones offer more inventory, a little wider open competition, instead of condensing it to just the corridors for the multifamily zone area. So it's opened up inventory. It's opened up more desirable neighborhoods where you can do these 3 unit, or maybe buy 2 lots next door to one another and do 6 units, and kind of achieve by scale by doing multiple projects what you would have done in a multifamily community where you might have developed 12 or 15 or 20 units. You're now doing them in pockets of 3 and 4 and 6 all over the city. And so some of the change and movement has been developers have moved out of the multifamily zone and into the single family zone. But now with these new duplex, triplex, quadplex, you're going to see something in the single family zone that I think is going to look more similar to the multifamily product. Because a duplex or a triplex or a quadplex is normally the kind of row housing and townhome type design that you used to see more in the multifamily zone, is now for the first time going to start happening in these cities. But we haven't even seen those permitted yet, so they haven't come out as the cities are just now, as we speak, implementing their new codes in that regard. The other thing that's changing is, as I mentioned earlier, the original paradigm was, let's build the biggest primary house we can, and then let's get 2 more accessory dwelling units to be built in there that are only 1,000 square feet. So you kind of had a buyer for the single family that was one client, one buyer, and then you had a buyer for the more affordable 1,000 square foot homes. And as I mentioned earlier, some of the developers now are saying, even though I could build a bigger primary, I'm going to build a smaller primary that's going to compete a little more evenly with the accessory dwelling units, because as these homes hit the market, and with the interest rates and the other issues and the climate that's out there, the accessory dwelling units are selling quicker. And if the primary home can be built to kind of feel a little bit more like the accessories at a lower price point, then you might have more success in moving these at a little bit smaller scale in terms of square footage than you would by just maximizing out the square footage. So those are some of the changes. The other thing is that using combinations of tactics, such as maybe there's an existing home on the property that's only about 1,000 to 1,200 square feet, or maybe it has a basement and the basement doesn't count for the square footage that the city counts. And so we can take that home that's been there for 100 years and call that the accessory dwelling unit, call that the DADU, the detached accessory dwelling unit. And by doing that, it opens up the rest of the site to then have a single family home and an accessory dwelling unit that might be attached, maybe in the backyard. And so looking at what's there now in terms of maybe we can recharacterize it as a different type of structure in order to fit these other housing models that are coming forward so that we can keep the home that's there now and not really hamstring our ability to maximize the highest and best use of the lot in those other ways. That's one thing. The other is maybe to do boundary line adjustments or short plats or subdivisions in that regard to reconfigure the property to create multiple projects. So that if you buy a piece of property that has some ability to either subdivide the municipal way or a boundary line adjust it through the municipal process and result in 2 or 3 lots that are standalone building sites, and then on each one of those do 3 or 4 or more units, you can have an assemblage at that point that you did in multiple steps by having a strategy and a plan that maximizes the highest and best use through a series of steps that might involve actually municipal subdivisions as well as condominiums. And some of our clients have done, 2 single-family homes with an accessory dwelling unit and used the municipal unit lot subdivision to separate the 2 single-family homes. But now the accessory dwelling unit's sitting on one of those lots that were municipally divided with the other single-family, and that's not divided from itself. So we use the condo to separate the accessory dwelling unit, and you end up with a hybrid of something that was divided municipally as well as had a secondary layer of the condo on one of those subdivision lots that created the condo units to, in the end, get all of those dwelling units on something that can be bought and sold separately.
You just answered my next question for you, whether or not you could kind of mix and match the different product types.
Absolutely.
But here's a different question for you, perhaps relatively provocative. These middle housing laws are state level mandates, and cities have been forced to react, usually without much public input.
Right.
I'm really thinking about some of these East Side cities. You mentioned them, Bellevue, Medina, etc. Now, do these NIMBYs have a case in any of these municipalities to stop or slow down density coming into their neighborhoods?
Yeah, I mean, it is a provocative question, and because there's obviously there's different feelings and sentiments in different areas, and there's different sort of neighborhood characters and so forth. And one of the things, as we look at some of the benefits of all of these changes, one of the things that's a legitimate concern is the change of the character of single family zones, right? We live differently now than we did before, and we're moving towards this smaller home, smaller footprint, more gentle density, as it were, in the backyards and side yards. But for people who have been in a neighborhood for decades and have kind of grown accustomed to things looking a certain way, to have a state mandate come down and say all the cities that are usually fairly autonomous in how they develop their land use and comprehensive plans, being told there's a sort of standard way that everybody has to do it, and that involves allowing 4 or 6 units on a single family lot. The NIMBY, as you said, if for those who don't know what that means, the not in my backyard, I don't want to see a change. That's a legitimate concern as to the changes in character of the neighborhood. But we're finding that even people who traditionally were not in my backyard types a lot of them are now older and maybe into retirement. They're on a fixed income or they're not working anymore, and they don't want to move, but they really can't even afford to keep up with the property taxes. And now you have these opportunities with these housing products, whether it's the duplex, triplex, quadplex, whether it's an accessory dwelling unit or 2, you can go to a bank and say, hey, it's going to cost me, let's say $400,000, $500,000 to build this accessory dwelling unit in my backyard. But then when we do an appraisal on it, we see that it's going to be worth another $800,000 to $900,000 in value that you've created to the property in the overall net value. So the bank will say there's enough equity there, even without an income, for you to be able to afford to get the loan to construct it. And then as far as income is concerned, we'll look at the fair market value of the rental that would bring in. And the rental on that in many of these neighborhoods, particularly East Side neighborhoods, would probably cover the cost of that construction. Get $3,000 to $4,000 a month for rental income on a $400,000 or $450,000 construction loan, and it probably washes itself out. And now you have somebody who might have been a NIMBY over time saying, well, my grandkids are coming back. They can't afford a home, so I want them to live on my property now. We'll create a couple more homes and maybe extended family. We'll live a little differently with each of us having our own home on this site. And I can even get financing to build it and qualify for the income from the rental money that it can generate. And that's all just if you keep it all, right? You can sell these off as well and have a boon in terms of additional money for your own planning, for estate planning purposes. If you maybe want to build one or two of these and move into one and downsize and sell off your main house, or but build one and sell it off and just not use your backyard that was maybe just blackberry bushes and causing a lot of pain to have to even upkeep it. Now you've all of a sudden created several $100,000 of value to just sell and get rid of the backyard. So it's created some configurations that I think even getting away from the builder's perspective is what about just homeowners who maybe on a grander scale saying, I don't really like all these changes to the way the planning is going on this, but maybe it gives me an opportunity to realize a lot of extra value in my yard as well.
Great. Well, Terry, we're all UW graduates, and it's coming to that time where graduation is just around the corner. And when I have guests come in to speak, I always hope what students remember one thing I say during the day. That's a win. So I want to ask you, if you had one bit of advice you could give to a young real estate professional or developer or investor, what's one bit of advice you might share with them?
I love that question. We get asked that a lot in the different presentations on these matters. And what I would say is, you're looking at me now with this beard and the Western wear and sort of this pioneering spirit. And I kind of look at, what I know of Washington history in terms of the gold rush of the late 1800s and Seattle kind of coming onto the map as an outfitter of sorts and how it grew. And then in post World War II nationwide, you have, GI Bill and you have people moving into suburbs. You have some pretty significant moments in history where housing and people's understanding of how to live in cities and suburbs really changed in dramatic ways. This is one of those times, in my view. I don't know that we'll see in our lifetime something as significant as this, because once the single family lots are used up, that's kind of it until you go up rather than out. And right now we have a lot of inventory across the state in single family zones that's untapped for this middle housing type of product. So my advice is you don't necessarily need to grow a beard and start wearing belt buckles and cowboy boots like I do, but do what it takes to get your mindset into a shift of paradigm. When we talk about subdivisions and lot splitting and unit lot subdivisions, and does the project have an HOA? Does it not have an HOA? Is it a condo? What is it? Is be open to understanding that the market is moving forward. Different buyers are moving forward. We have 1 million people coming into the area in the next 15 to 20 years. They're going to have to go somewhere. And the idea of using the old ways of thinking to address what has become, just as you and I know from being in our 50s, you go back to our 20s when you could go to UW and you could work in the mall and have a part-time job and pay for your school and even get your first condo coming out of college. You can't do that anymore. I got kids in their 20s. It's a different world 30 years later, and this is an unsustainable trajectory. So keeping things moving forward in a more productive way means changing your mindset and being willing to think about things in new, even revolutionary kind of ways compared to the past. So use your old tools if they're helpful, discard them if they're not, but put on the kind of hat that allows you to think in these things in new and refreshing ways that to address the new realities that we have.
That's great advice. So Terry, what's your background and how did you get into law and real estate law and in the development space?
Well, I was a UW grad for my undergrad in communications back in the 90s, and I thought about wanting to go to law school, but it seemed like it might be a little too tall of an order at that time. I just got married and had my first kid a few years later as well. And so I got a job working in a land surveying company that belonged to my father-in-law. And that's actually where I met Jeff 30 years ago. And through the surveying lens, I worked with all the jurisdictions as the project manager planner for permitting for mostly subdivisions, small short plats, unit subdivisions, full-blown plats, and other types of projects that were having to get reviewed by all the different municipalities. And what you realize is there's all these different cities and counties that review things a little differently. They all have different zoning, different implementation. They review products, the same product in a different way. Even within jurisdictions over the years, you'll see different policy changes and shifts in the way they look at the same thing they did 10 years ago. They do it differently now. And that gave me a fresh insight as to all these variety of ways that things are dealt with through the surveying lens. Then I went to Seattle U for my law degree and I got a law degree in their evening program, as they offered a part-time program to go to school at night, and I was running the survey business by day. After the recession in 2008 to 2011, I pivoted out of the surveying and fully into the legal. And all of the stuff that's happened since 2011 and 12 to now has been this momentum building towards products that are how to create ownership opportunities, subdivisions and condos and so forth, that really involve both the surveying lens as a planner and as a map maker and an easement creator and all the different covenants and things that surveys have to look at, and all the legal side that an attorney has to look at to creatively use the law to come up with ownership packages that are the best suited and fit for the different types of products that are on these sites. And lo and behold, now those are the two hats that are mainly needed. And so my background has given me a fortunate situation where the surveyor and the attorney, as a real estate attorney, have both kind of parlayed into the things that are at this point in time in history really important to have some understanding of.
Wow, what a great path. Really right time and right place.
Totally.
And currently, how many condo or ADU or middle housing projects are you working on?
So we do one condo every business day on average all year long. So 20 to 25 condo communities a month, and then we have a handful of unit lot subdivisions and other types of short plats and plats as well. So maybe 30 plus projects a year or a month, every month, whether they be condos or subdivisions, but communities are being created at that pace. We have a little over 20 employees right now in the firm. And the question's been asked, do we want to keep on growing now that Eastern Washington, we're getting calls from, Lake Chelan and Spokane and other places. What do we want to do? And I guess my mind and my eyes are open to kind of keep looking at how this goes, and we'll see what the future holds. Right now, there's a lot of work to do right up and down the Puget Sound corridor, and we'll see if we can scale in a helpful way to address some of these other places that are now coming online, because it is all statewide stuff, and what you perfect in one place should hopefully have a lot of portability all around the state.
So what is the typical time and cost it would take to do one of these projects? And I know, it varies depending on the municipality and the size of the lot and the project itself. Uh,
Yeah.
but I guess just from a legal standpoint, what are we looking at?
So from the subdivision standpoint, that can be anything from a year to 10 years, depending on the complexity of a subdivision. A unit subdivision, which lays on top of a building plan, is typically faster, maybe 6 to 9 months. Some of these new cities coming on board, maybe they'll be closer to a year. I think most jurisdictions would hope to get tightened down to maybe a little bit more what Seattle has been doing on unit subdivisions, which is more in the 6 to 9 month range. So that's municipal processes. The lot split in the next 2 years, when that gets implemented, I mean, the talk on that is that hopefully that's a few months rather than it's faster than maybe a unit subdivision as well. There's no public notice. You'll curb some of the steps involved, and so we'll have to wait and see. But maybe a 4 month period for that would be my guess. It's is at this stage in time, just kind of looking and forecasting. I guess the beauty of the condo is if you want to go that route and create it that way, which you usually always have that option, that's as however long it takes the surveyor to make a map, and then a couple weeks after that to do the legal work to create it through the law firm. So you might be only looking at a month or two in most cases. And so depends obviously on the other complexities. If there's other easements or neighbor issues, adverse possession, all this, that's some things. You've got other things that can impact a project, but just the legal side of creating the paperwork to create something that can be recorded and sold, at least in the condominium lens, is pretty fast. And we'll see how that works out as we go spreading out now to other jurisdictions across the state, if that timeline stays in order.
And now, Terry, for us visual learners, is there a particular project that you're very excited about? And if we were to go online, could we see an example of what these middle housing projects look like?
Yeah, there's some really neat creative things, and architects now that they're an industry that's really in demand in my view. When you look at what the highest and best use of a property is, getting away from just some of the land feasibility things, is what's the product going to look like? And I've seen some really neat things, and maybe that's also where the condominium offers some flexibility, even where you have a choice of doing a subdivision versus municipally versus a condo. One of the things about a condo, since it's not municipally reviewed, is you have a lot of creativity that you can bring to the table and how you might design the ownership and the use of a particular piece of property. And one of our clients did a project over in Magnolia that was on a hillside. It was 5 stories tall. The first 2 stories were the dadu, which were comprised of a at-grade level garage, and then second floor is the 1,000 square foot 2 bedroom dadu that sits above the garage. Behind that, up the hill, 3 stories for the primary structure. and a beautiful home with a view for the primary structure, creating those 5 stories. And then the first floor on the ground level at grade, where the garage was, has an elevator. It goes up, and it's a common element that we used in the condo that's shared by both homeowners, so that it can go up to the dadu level and let off there, or go up to the rooftop of the dadu, which served as a extra patio and deck area for the primary home in the back. So the home in the back is literally using the roof of the dadu for an outdoor living space. The dadu didn't need an additional deck because it actually had a deck on its main second floor as well. So everybody got their own deck and view, and the condo allowed us a lot of creativity in assigning spaces like rooftops and elevators and parking to whoever we wanted to be able to have the rights to use those spaces. So stuff like that, I think that's an extreme example of just kind of what you could do if you want to sit down with your architect and think about, how might I design this site so that it can operate really well for the homeowners.
And that's great, because I think we get back to, you and I have done many of these talks over the last couple of years. It's about building your team, right? You talked about the need for architects, right? And a good real estate broker and a good attorney and a good surveyor. You need an arborist and geologist and a wetlands biologist. All these parts go into it. So, putting your team together to be creative and trying to figure out, well, we're going to keep the house, we're going to scrape it, start all over again, but what's the best way forward? As you mentioned earlier, what's the highest and best use for the site? What can we do here? And finding something that creates value for the homeowner, hopefully that gets to retain the value, or for the developer coming in, but someone who, before they sell, they should be talking to their broker, Dylan, and say, what can I do with this property? And before I list it, what are some things I should know? So get into this. So if people want to reach out or learn more about you and your services, Terry, what's the best way for them to do so?
Well, they can go to our website, which is wilsonlawgroupwa.com. Some people have a hard time remembering that, so we created the moniker who'syourdadu.com and bought that site. So if you type in Who's Your Dadu, you're going to go to our website. But we also have that Who's Your Dadu moniker with TikTok and Instagram and Facebook and so forth. So you can find us on those searches. You can also go to just the wilsonlawgroupwa.com and get launching points there for all of those different social media outlets. We try to put little educational clips on some of these up and coming things and understandings on there, just to give bite-sized 3 or 4 minute little spiels here and there to help both entertain and educate on some of these matters.
And I've really appreciated those. I've seen them. I've learned things from them. So I encourage everyone to do so. So Terry, thanks for coming on today, sharing more knowledge with us.
Thanks for having me. It's great as usual.
Thank you, Terry.
Thanks, guys.